law, that's something that is not well accepted by common lawyers. And the way we came at the end, after long weeks of hearing many experts, many witnesses, so we came to the conclusion in the deliberation that there was no expropriation, that there was no violation of the EPSA, and we wanted to allow Qatar to continue exploiting the natural resources, especially the gas natural, which was, the natural gas was very important resource in this country. And we adapted the contract in our discussions, taking the good faith enforcement of the contract. That was not possible if we happened to go in the common law proceedings. And that was the reason why I thought it was very important, and we managed to decide that Qatari law was the choice of law we took. Second case I want to draw your attention. Many years ago, I was a young university professor with a PhD in Germany, and I received a call from the ICC headquarters saying, Mr. Cremades, do you want to chair an arbitration tribunal in Vienna? Of course, Vienna, as you know, in Austria, they speak German. And they wanted me to be the chairman of that tribunal because of my PhD in Germany. I accepted, and I went to Vienna, and the problem was between a Turkish company and a French company. There was no choice of law, and due to the fact that the ICC decided that the seat of arbitration was Vienna, the arbitration should be conducted in law and not in equity. And if we accepted the law of Turkey, we had to go one way, and if we accepted the law of France, due to the public order of vis cachet, we had to go in another way. So we said, well, both parties have good reasons to come to us. Why we don't apply lex mercatoria? Why we don't apply the general principles of law? And that's the reason why we decided applying general principles of law. And the party who lost went to the challenge of the arbitration award, first to the Court of Appeal in Austria, and then to the Supreme Court, saying, these crazy arbitrators, they have changed the arbitration. Instead of applying the law, they have made an arbitration in equity because they were applying the principles. What the Supreme Court of Austria said, principles of international law are part of the law. Applying the principles of international law, it's applying the law. And they said, we ratify the award like it was drafted by the arbitration tribunal. And then the party who wanted to execute that in France did the same thing. The other party said, no, ordre public. They have changed an arbitration in law into an arbitration in equity, and that's against public order. They went to the Cour de Cassation at the end, and the Cour de Cassation said the very same thing. Applying principles of international law is not doing an arbitration in equity, but is an arbitration applying the law. As you can imagine, there was, at that time, a huge discussion about lex mercatoria, especially coming from the other part of the channel. They were totally against lex mercatoria, saying these crazy continental lawyers are using a terrorist way of applying the law. But anyhow, you see how important is the choice of applicable law. Nowadays, many contracts, without saying international contracts, without having choice of law, arbitration tribunals, they say, why we don't apply UNIDROIT principles? because UNIDROIT principles is the most international way of applying the law. And nowadays we have a lot of arbitration tribunals using the UNIDROIT principles when there is no choice of law. Third arbitration case I wanted to draw your attention. I happen to be chairman of Al-Warrat against Indonesia. This arbitration, investment arbitration, was applying for the first time, and now it has been applied many times, the agreement on promotion, protection, guarantee of investment among members of states of the Organization of Islamic Conference. And if I take this case here, is because of the importance of this agreement in investment arbitration in the region. Nowadays, it has been quoted many times, this arbitration award. And what they said in Article 9, the investor shall be bound by the laws and regulations in force in the host state. So you see what they say in this investment arbitration treaty. Anyhow, I think the coordinator looks to me saying that the time is over. Thank you very much. Thank you.
Thank you, Professor. Very enlightening presentation on how the application of the law would change the outcome of the award and also impact the state itself, especially the first case you mentioned about Qatar. Now we will move to our next panelists. I wonder whether the online Professor Mohammed Sami Hamr will be joining us online. I wonder whether is he available now or... Yes. Okay. Professor Mohammed Sami Hamr was not able to join us in person, but he will be joining virtually. He is a distinguished academic and practitioner in international law, currently serving as the Dean of the Faculty of Law at Cairo University. He holds a prominent position as the managing partner of Amr and Partners law firm in Cairo and as an independent consultant based in Paris. Professor Amr is a member of ICCID panel of arbitrators and has acted as an arbitrator under various prestigious arbitration rules, including those of QICCA, CRC-ICA, DIAC, ICC, and the DIFC-LCIA. With a wealth of experience in both academic and practical domains, Professor Amr has held significant diplomatic roles, including Ambassador of Egypt to UNESCO, and has advised the Egyptian government on critical international legal matters, such as the Nile River dispute. He has authored numerous publications in the field of international law, particularly in areas related to international arbitration. Despite the distance, his contribution will undoubtedly provide valuable perspectives on the law applicable to the procedures in arbitration, drawing from his extensive experience as both an academic and practitioner in the field. We are honored to welcome Professor Amr. We are all ears to hear your presentation.
Dr. Tariq, do you hear me?
Yeah, we are hearing you.
Okay, perfect, because it's from the other side, I can't hear you well. First of all, I would like to thank you for moderating this session. I'm really sorry and I regret that I'm not able to be with you physically today since I have a hearing that I could not really make any changes to the schedule. And I would like to thank all the organizers of this very important event that they allowed me to be with you online and virtually. Actually, I would like to address the topic with my esteemed colleagues of this panel, who I do respect highly. And I would like to address the issue of the law applicable to the procedure, because this issue nowadays raises a lot of concerns, and it opened a big room of debate. As you can see on the screen, we have two theories in this regard. Either the arbitration is considered localized, or arbitration is considered delocalized. Those are the two main streams that we have these days. And as you know, that the localized is a theory that gives effect to the choice of the seat, where when the parties choose a seat, they in turn select the law applicable to the procedures with it. While in the delocalized theory, it gives no effect to the choice of the seat, whereby the choice has no legal impact on the procedural law applicable, as an arbitral award is transitional judgment not subject to any national laws. And nowadays we have those two theories applicable, valid in some jurisdictions. Some jurisdictions take with the localized and others take the delocalized, and I will briefly present the two theories in front of you. The localized theory, it depends on the freedom to choose of the parties to choose the law applicable, whether adjudicated subject matter litigation or arbitration, or the procedures in arbitration. And if we go back to the unilateral model law, it criticized this in Article 19.1, which states that subject to the provisions of this law, which is unilateral model law, the parties are free to agree on the procedures to be followed by arbitral tribunal in conducting the proceedings. The localized theory is that the law applicable to arbitral proceedings, in the absence of choice of law by the parties, would be the law of the chosen arbitration seat. And this is important, that they, in this case, will go to the law which is applied in the seat that they have chosen. And that once the parties choose the arbitration seat, they impliedly choose the arbitration law of this place. And here, as you can see on the screen, I give you a very quick example of that. Any dispute arising, let's say, any dispute arising, if this is the arbitration clause related to this agreement, shall be resolved through arbitration under QICCA rules, for an instance, through 3 arbitrators. To the end, the arbitration proceeding shall be seated in Egypt and governed by English law regarding substantive matter of the dispute. Therefore, we have the following. We have the substantive law is the English law, the applicable procedural law is the Egyptian law, and the applicable center rules is QICCA rules. This, however, that the arbitration law, which is the Egyptian law in this case, is not only the procedural law applicable, but it is in addition to the arbitration center rules and the procedural rules in a procedural law governing civil and commercial proceedings, which is Law 13 for 1968. We call it the Egyptian Code for Civil and Commercial Procedures and its subsequent amendments. So, the critical issue we face in practice is the issue of notices. When we deliver a notice, this means that we have to apply the said law as per Article 7, which says that the communication should be directed by any letter or any written communication and to be delivered to the addressee personally at his place of business or residence or mailing address, known to both parties. And it defined the arbitration agreement or in the document which contains the relationship subject to arbitration. If there is no address can be identified after having made a reasonable inquiry, communication to the addressee is deemed to have been received if it's set in the form of a registered letter to be to the addressee, last known place of business, habitual residence, or mailing address. The issue of notice is very important because if the court cannot make sure that the other party is not notified as per the law, this can lead that the award later on will be null and void. And that's why when we deal through any arbitration center, I'll give you an example of the Cairo Regional Center in this case, that we insist to address to the designated party any notice and to be delivered to them in order to ensure that, or in order to protect the award later on, and to ensure it will not be null and void. So in the case of absence of such designation, agreement, or authorization, a notice is deemed received. If it's physically delivered to the address of the or to its representative, or if it's delivered to the place of business, whether resident or elected domicile or mailing address. The issue of notices is covered also by Article 4 of the same, by paragraph 4 of the same article, which is 7, which states that if after reasonable effort, delivery cannot be effected in accordance with paragraph 2 or 3 of the Article 7, a notice is deemed to have been received if it's sent to addressee's last known place of business, residence, elected domicile, or mailing address by registered letter, or any other means which provide a record or deliver. If it's delivered to any relevant location mentioned in any contract or other legal instrument out of or in relation to this dispute, or if it's delivered by email address, which the address hold out the public in the time of such communication. So based on previously mentioned provisions, arbitral tribunal should presume the satisfaction with applying either the center rules or the following requirements by the law. In certain matters, like notices, they are of a significant importance that can impact the award, as I said earlier. Therefore, the arbitral tribunal resort to apply the procedural law governing civil and commercial procedures in the absence of the participation of any party to the dispute, especially in our cases, it's the respondent. So the notices, and this is also the importance of the notices, is addressed by New York Convention, which states in Article 4 that recognition and the enforcement of the award may be refused at the request of the party against whom it is invoked only if that party furnished to the competent authority where the recognition and the enforcement is sought prove that the party against whom the award is invoked was not given proper notice. So the most important thing when we enforce the judgment is to make sure that the party was given a proper notice of the appointment of the arbitrator, of the arbitration proceedings, or otherwise to enable this party to be present in the case. Simultaneously, the Egyptian law states in Article 53, the procedural law, it states clearly that any arbitral award may be annulled only if either party to the arbitration was unable to present in case as a result of not being given proper notice of the appointment of an arbitrator or arbitral proceedings or any other reason behind its control. So the notices is governed by the Egyptian law under the Egyptian Code of Civil and Commercial Procedures law under Article 10 and 11, which is a safeguard for any award. And I'm not going to read out those two articles because it should be known to everyone. However, the most important thing is that we have to make sure that we follow these rules in order to protect any award. The other theory, which is the localized theory, which is followed by the French practice. And this theory takes us to that they don't follow the subject of the laws of the seat of arbitration or any national laws, other than where the enforcement is sought. And this is what is applied by the courts in France. In the courts in France, they go to, when you go and enforce the judgment in France, they look at the French law regardless where the seat was, Egypt, Qatar, or anywhere else. So the concern should only be given to the law of the place where the arbitral award would be enforced, not the place where the arbitration takes place. And this is the big difference between this theory and the other theory. So the other theory, localized, it relies on where the arbitration takes place. The delocalized, it focuses on where the award will be enforced. This is, we find out in the several courts judgment by the French Court of Cassation in different cases, as you see on the screen, where the court stress that the most important thing in France is to look at the rules of notice, the rules of procedures, where you enforce the judgment. This is also applied in case of the investment arbitration, not only in the commercial arbitration and in investment arbitration. They follow the delocalized theory, not the localized theory, where they focus only on the country where they enforce the judgment, because normally the investor, if they obtain the award in his favor, they don't go to the country where the judgment is issued against, but go to enforce on its assets anywhere in the world. So when they go to any other countries, they prefer to follow the delocalized theory, and this has happened in different jurisdictions, like in the United Kingdom and United States, where in different cases they look at, in the United States, in this case that you see on the screen in front of you, they only apply the United States Federal District Court, which is not the local one of the state that the judgment, even the seat is different. They apply wherever it applies and that's exactly what is followed in the US courts in different cases,
Dr. Sameh,
and the UK courts,
if you can
different
please
cases, where they
finish
go
within
to
2
apply
minutes.
this theory for any enforcement of the judgment. I hope that this clarify what we mean by the two theories, and I will stop here. I will not take more time. I understand it's not easy to present that from distance, but those are the two, and I'm sure that the discussion during this session will focus or will address this issue in a way or another. Thank you, Mr. Moderator, Dr. Tariq. Thank you for everyone. Thank you for the organizers for giving me the chance to be with you even virtually.
Thank you, Professor Amr. Thank you for your presentation and the distinguishing between the localized and the delocalized theories in respect of the procedural law applicable to the arbitration. Now we will move on to the presentation of Professor Jung-Gi Kim, a highly respected figure in the field of international arbitration with a distinguished career that bridges academia and practice. He is a professor of law at Yonsei Law School in Seoul, where he shares his extensive knowledge with students and contributes to the development of legal scholarship. Recognized as a global elite thought leader by Who's Who Legal, Professor Kim has been honored as the International Arbitrator of the Year by QICCA International in 2019. With vast experience as an arbitrator across major leading institutions such as QICCA, QICCA, ICC, QIAC, and UNICITRAL, Professor Kim's expertise covers a wide range of commercial and investment arbitration issues. He also serves as a member of the ICC Court and is actively involved in shaping the future of arbitration through his role on the Academic Council of the Institute of Transnational Arbitration. We are privileged to welcome Professor Kim as he presents on a highly relevant topic, recent developments in the debate concerning the applicable law of arbitration agreements. Dr. Kim, Professor Kim, please.
It's a great pleasure to be here. Assalamu alaikum. I'm going to present on the choice of law in arbitration agreements, and of course the debate, that a perennial debate, the vexing debate that exists between whether it should be, which law should apply. And of course, this is actually a very important issue because which law that applies to the arbitration agreement affects many, many things about our arbitration. It affects potentially the validity of the arbitration agreement, the formation of the arbitration agreement, the termination of the arbitration agreement, the interpretation of the arbitration agreement, waiver of the arbitration agreement, the parties to the arbitration agreement. There's so many aspects of the arbitration agreement that are affected by the applicable law of the arbitration agreement. Now, why does this get complicated? If life was perfect, of course, this would be a very simple exercise. But of course, life is not perfect. And as Bernardo just showed us, there are many cases where he actually already personally experienced. So, put it simply, we have four basic situations. One is where, as we saw in Bernardo's various cases, is where there's no governing law. The parties did not choose the applicable law of the contract, of the dispute, of the container, the main contract. Or, in addition, they did not designate a seat or place of arbitration. This is probably, of course, from an arbitration standpoint, your worst case scenario. So you have nothing to start. The second situation will be they at least designated the seat. The seat of arbitration is Dubai, or it's Doha, or it's Cairo, or it's Tokyo. At least the place was designated, but the governing law was not designated. The third situation is where the governing law, the choice of law, is designated. It's Qatari law. However, the parties did not mention the seat of the arbitration, the place of the arbitration. So in those two, the green box and the yellow box, at least you have something going on there. You can latch on to that potentially, and some might suggest, therefore, in the green box, since there is a seat, and the seat in that case was Doha, then that Doha potentially is implied to be the applicable law of the arbitration agreement. In the yellow box, at least you have the governing law of the contract. So seat is missing, so you can imply, perhaps, that that law would govern the arbitration agreement. So those, you have something to latch on. The complicated one, of course, for us is the final box where there's a conflict. One is Qatari law is the governing law of the contract, and the seat is Singapore. It's not Doha. It's somewhere else. Then you have the seeds of our conflict. And broadly speaking, the potential options in that case are the law of the seat determines, and this is what Gary was mentioning earlier, of course, law of the seat should determine, and Gary feels very strongly about this, and he told us that's when you swipe right. Or should it be the governing law of the contract, which determines the governing law, the applicable law of the arbitration agreement, which, from a layman's perspective, that might make sense. Layperson thinks applicable law of the contract should be the same as applicable law of the arbitration. Two more examples do exist. One is the validation principle, which is adopted by some countries. Leading ones would be Spain and Switzerland, where the law that makes the arbitration agreement valid, whether it's the law of the seat or the law, whatever makes it valid. The parties wanted arbitration, they wanted it to be valid. So whatever makes it valid, that should be the one. And then, of course, you have kind of the French approach, which is what the parties consented to. Now, there's a global survey done on this issue, and this kind of summarizes the global trend of this debate. The blue are those countries that have adopted the law of the seat approach. I note that they missed Korea. For some reason, they have North Korea, but I think they meant to mean South Korea. And then the green are those countries that have adopted the law of the main contract approach. Those are the predominant two options that exist in our world. You do have the others, but I want to focus on the two because those are the predominant ones. Now, if you look closely at this, one might jump to the hunches that you have, of course, UK, US, India, Australia. So largely speaking, the common law countries generally adopt the law of the main contract approach. If you look carefully, however, there are some exceptions to this. And this is interesting. And of course, one might suggest these are kind of progressive jurisdictions, and those are in the far corner in the right, New Zealand, and in the far corner above the UK, Scotland, and then in Africa, Nigeria. These are three common law countries that have gone against the grain and adopted the law of the seat approach. And the rest of the world, about more than half, most civil law countries, of course, most of the laws of the world are civil law, they generally adopt the law of the seat approach. However, there are exceptions to that as well, even among civil law countries. And if you note, the main ones are countries such as Germany, Austria, and I caught in the region, Iran. Iran are the exceptions, and they adopt the law of the main contract approach. So that's the debate between the law of the seat or the law of the main contract. Now, so the question is how to resolve this debate. And one interesting example, and I'm not aware of any others, is what the HKIAC did. This is the Hong Kong International Arbitration Center. They said, there's this messy debate, and of course Hong Kong is a common law jurisdiction, and they adopt basically the UK approach, which is the main but they suggest in their model arbitration clause, parties should just stipulate this. Because if you just state it, then it's clear, and then you don't have to have this debate. But they're the only arbitration institutions that I'm aware that have gone this route, which is a good idea because clarity clears things up for us. Now, as Gary hinted earlier today, this is the big change. The UK Law Commission has proposed that they shift from the governing law of the contract to the law of the seat approach. And the question is, what is this going to do? And of course, it's interesting because most countries of the world, they've settled this dispute through the courts. The courts have been deciding. But this is an approach where, by law, by legislation, they're basically turning the tide against what the UK Supreme Court has consistently held. They're adopting a legislative approach to say, no, you have to go by the law of the seat. That's what the proposal of the Law Commission is, and it is most likely going to be adopted. And of course, Gary swipes right and suggests that is the right approach. So, the question is going forward now, and of course, UK is a major jurisdiction in our arbitral world. What is that going to do? Are other countries' jurisdictions going to follow the UK approach and shift? Are those, particularly those common law jurisdictions, going to shift? Which ones are going to change? And of course, how will they change? Will they do it by legislation? Or will they leave it to their courts? Or, as we saw in the HKI situation, perhaps some of their institutions might adopt more like the HKI approach. This is what we shall see. Thank you so much.
Thank you, Professor Kim. We have now maybe a shift in the approach, whether to apply the seat of arbitration or still apply the law governing the contract. So we will see later in the discussions. Now, Professor Dr. Nader Ibrahim, who is a renowned professor of commercial law at Qatar University with a career spanning over 25 years in academia and international arbitration. He holds a PhD in international commercial arbitration from Alexandria University and an LLM in international business law from the Sorbonne program at Caire University. Before joining Qatar University in 2016, Dr. Ibrahim served as Dean at the Arab Academy for Science, Technology and Maritime Transport, an accomplished arbitrator affiliated with leading centers like QICCA, QICCA, and the DIAC. Dr. Ibrahim's research focuses on arbitration and commercial law from the Arab perspective and is widely cited in leading Arabic legal scholarships. We are honored to invite Dr. Nader Ibrahim, to present on the applicable law to arbitration agreements and Arab law perspective.
I kicked too many times, so it took me to the end of my presentation. Sorry about that. To my colleagues, I have been planning to speak in English. because I think my presentation is a kind of extension or development of what has been said by my colleague Jungi Kim. But if you don't mind, I wish to speak in Arabic. Since most of the audience, I noticed that they are Arab speaking. أنا في منتهى السعادة أن أنا أكون بينكم اليوم. بحسب الأصول ينبغي أن نتوجه بالتحية والتقدير إلى القائمين على هذا العمل الجاد، وعلى رأس ذلك العمل الشيخ دكتور ثاني وفريق العمل أستاذ خالد وكل الفريق العمل. فبشكرهم على ثقتهم وعلى هذا العمل الرائع الذي أتاح لي أنا شخصياً يعني اليوم في منتهى السعادة، لأني أجلس في يعني بانل بين بعضه أساتذة كنت أقرأ لهم من 30 سنة يعني. فكرر الشكر. أيضاً أحد الأسباب التي جعلتني أفكر في أن أتحدث باللغة العربية هو أستاذنا وعمدنا في المحاماة والقانون والفقه القانوني أستاذ يوسف الزمان، لعلي أستطيع أن أتحدث معه في المناقشة، يعني أدفعه أن تكون مقدمة للمناقشة. يقولون إذا أردت أن تعطي محاضرة الأفضل ألا تنظر على الناس واحكي لهم قصة أو حكاية. والحقيقة بروفيسور كريماريس عرف يعمل القصة دي كويس، فأنا بحاول أعمل زيه. أنا عايزكم ترجعوا معايا على مصر. إحنا بنتكلم على قانون واجب التطبيق على اتفاق التحكيم. فترة الخمسينات، الستينات، وصلت حتى فترة الثمانينات، متهيألي مستمرة حتى الآن. معظم البضاعة تأتي إلى جمهورية مصر العربية عن طريق الإسكندرية. البضائع اللي هي كميتها كبيرة، حبوب، زيوت، إذا أنت اشتريتها بنظام عقد البيع سيف، هذا معناه أن المصدر سوف يبرم عقد النقل، ونظراً لأنها بضائع كبيرة فهو سوف يستأجر لك سفينة. أنت كمرسل إليه لست طرفاً في عقد الإيجار، تستلم البضاعة، تجد فيها تلفاً، تذهب إلى القاضي تقول له عايز تعويض. يبدأ يدافع عن نفسه الناقل، يستخدم كل الوسائل الممكنة حتى لو كان عارف أنه هو غلطان يعني. فكان أساتذتنا يقولون لنا في محاكم الإسكندرية وصلت لدرجة أنه يختصر الدفوع في 3 كلمات، وكان أول كلمة هي أنا بدفع، رقم 1 التحكيم. هناك شرط تحكيم، لأن المشارطات بتستخدم اللي هي مشارطات الإيجار، عقود إيجار السفن، بتستخدم نماذج، وهذه النماذج أغلبها يوجد فيها شرط التحكيم، ويقول أن سند الشحن قد أحال إلى مشارطة. هذا أمر. ما الذي كان يفعله الشاحن؟ كان يقول وعلى فرض أن هذا الشرط موجود فهو باطل. لماذا؟ مصر قبل 1994، احنا كبار شوية يعني، كان فيها قانون ضد التحكيم. كان هناك مادة مشهورة في قانون المرافعات 502 فقرة 3 تقول إنه شرط التحكيم حتى يكون صحيحا ينبغي أن يذكر اسم المحكم في شرط التحكيم. الآن أنت أمام القضاء المصري، وصل لغاية محكمة التمييز. ما هي الاختيارات؟ لديك اختيارات عدة. أنت ممكن أن تقول الذهاب إلى دولة أخرى سوف يحرم الشاحن من حماية القواعد الآمرة، وعندئذ سوف تقول أن هذا الشرط باطل. لا أود أن يتحول هذا الشرط إلى وسيلة غير مباشرة إلى حرمانه من الحماية المتوفرة لدينا. هذا موقف القانون الأمريكي قبل سنة 96 لما صدرت السكاي ريفر، واللي عملت شفت وقالت لا، سوف نعترف بشرط التحكيم ولا نستخدم حجة الحرمان من الحماية. هناك حل آخر، إنك تقول نطبق القانون المصري، لأنه القانون واجب التطبيق على العقد، والقانون المصري في قانون المرافعات بيستلزم اسم المحكم، وبالتالي الشرط باطل. محكمة التمييز المصرية، وعلى الرغم أن التشريع لم يكن مناصرا للتحكيم، كانت مناصرة للتحكيم، بل أستطيع أن أقول لكم كانت مناصرة للتحكيم أكثر من الهاوس اوف لوردز. وأعطيكم مثال. كانت تناصر التحكيم فتقول: أولاً، هذا الاتفاق هو اتفاق في شأن إجراء، وحسب قانون المرافعة، حسب قانون تنازع القوانين، فأن الإجراء يخضع لقانون مكان الإجراء، ومعظم هذه التحكيمات في لندن أو في الوست، إذن سوف نطبق القانون الأجنبي. هذه واحدة. ثانياً، كان الشاحن يقول لها: ولكن هذا القانون مخالف للنظام العام، لأن المادة 502 بتتكلم على قاعدة آمرة. كانت تقول له: هذه القاعدة آمرة ولكنها ليست متعلقة بالنظام العام. رقم 2. بل كانت تقول له: أنا سوف أرتضي حتى ولو سند الشحن لا يوجد فيه شرط كلمة تحكيم، يعني عندما أحال لم تكن فيه كلمة التحكيم، وهذه هي الإحالة العامة، وأنا عارفة أن هي إحالة عامة وأنا أرتضيها وأكتفي بها. يقول لها: إذا إحنا رحنا إنجلترا نفسها ما عندهاش إحالة عامة، الإحالة عندها إحالة خاصة. له أيوة أنا عارف أن عنده إحالة خاصة. فكانت إذا ما سوف تؤدي القضية إلى إنكار العدالة، بمعنى أنني سوف أذهب إلى إنجلترا، ولكن في إنجلترا لن يعترفوا بشرط التحكيم لأنه شرط تحكيم بإحالة عامة وهم لا يأخذون بالإحالة الخاصة، قالت له: عندئذ فقط سوف أجعل القضاء المصري هو واجب التطبيق. هذا الكلام خلاصته أن كما يقول أينشتاين أن كل الأمور أصبحت نسبية. أنني لا أود أن أقول مثلا لأستاذنا أستاذ يوسف أنك أنت مخطئ عندما تطلبت أن يكون الإحالة خاصة وأن قانون التحكيم قال واضحة. ما هي الواضحة؟ واضحة ينبغي أن تكون خاصة. وحقيقة أنا أثناء عرضه للمحاضرة حاولت أن أذهب إلى الدايجست بتاعت الأونيسترل، وأذهب أشوف ماذا فعل القضاء المختلف فيما يتعلق بالواضح. هذه البعض فعلا قال كما قال أستاذ يوسف: ينبغي أن تكون الإحالة إحالة خاصة، ولكن البعض الآخر لم يستلزم ذلك، بمعنى اكتفى بالإحالة العامة. إذن المسألة مسألة سياسة. هل أنت تود أن تيسر للتحكيم أو أنت تتشدد؟ وبالتالي أصنف الحكم الذي ذكر صباحا بأنه ييسر التحكيم ولا يتشدد فيه، وهو لم يأتي بجديد. هذا اتجاه معروف على سبيل المثال عندنا في مصر. إذن اتفاق التحكيم اتفاق في إجراء. إذا فتحنا أهم كتاب في الفقه الإجرائي يتحدث عن التحكيم، سؤال هاتي في الامتحان: من هو أفضل كتاب كلنا نفتحه لكي نقرأ عن التحكيم؟ قولوا أنتم لنا. فتح والي. إذا ذهبت إلى فتح والي ففي النسخة الأولى والثانية والثالثة، وهو أصنفه عميد الإجرائيين، يقول هو ليس اتفاق في إجراء. لماذا؟ يقول أن المحكم ليس طرفا فيه، لا أطبق عليه نظرية العمل الإجرائي، لا سقوطا لا بطلان، وبالتالي هذا ليس اتفاق في إجراء. طيب إذن هو ليس اتفاق في إجراء، ما هو إذن؟ هو مثله مثل كل العقود. هل هذا التكييف تكييف صحيح؟ تستطيع أن تقول أن هذا تكييف صحيح. أود أن أقول أن محكمة النقد المصرية عندما قالت هو اتفاق في إجراء، أكاد أقول أنها كانت تعلم أنه لربما هذا التكييف ليس دقيقا، ولكنها كانت تقوم بما نطلق عليه في علم القانون الدولي الخاص، وهناك زملاء في الدولي الخاص معي هنا، التكييف الوظيفي الغائي. هي بتعمل تكييف بهذا الشكل لأنها تريد أن تصل إلى نتيجة معينة. لا أود أن أطيل، أود أن أجعل ما أقوله متصلا مع ما قيل من زميلي جونجي. إذا سمحتوا لي بس أقوله باللغة الإنجليزية. If I will try to connect the conclusion of what I have said with the conclusion that presented by my colleague Junki Kim, that the established rule according to our cassation case law is that when it's an arbitration clause or arbitration agreement and you want to determine the applicable law, you will go to the lex loci arbitrary. This is because the court, the cassation court in Egypt, classified the arbitration agreement as an agreement on procedure. This is debatable, but shall this be changed? I doubt it, especially after what we have witnessed in the world, especially in the UK, of the CHOP precedent. I was expecting that somebody will elaborate on that. إنه في العالم الآن بدأوا يتحدثوا عن مشكلة القانون واجب التطبيق على اتفاق التحكيم، وإنه فلنذهب. على فكرة ده مش حل ممتاز إنك أنت تذهب إلى مكان إجراء التحكيم، لأن إحنا مش عارفين هيجرى فين أحيانا. Therefore, I think the question is still open. What is available is to apply the lex loci arbitrary. But shall this be changed? I doubt it. And thank you.
Thank you, Professor Zander. Well, I think that also the Egyptian court was also trying to validate the arbitration agreement, as Professor Kim also presented in his presentation, that usually you look forward to try to give effect to the arbitration agreement, that this is a very good approach to be in favor of the arbitration. Now we have our final panelist, Professor Lucas Mistelis. He's an international arbitration partner at Clyde & Co. in London, and the Clive Schmidhoff Professor of Transnational Commercial Law and Arbitration at the Center for Commercial Law Studies, Queen Mary University of London. He was the world's first professor to hold a dedicated chair in international arbitration, reflecting his pioneering contributions to the field. An acknowledged authority in international dispute resolution and investment treaty law, Professor Mistelis has been consistently ranked among the top legal experts in arbitration. He features in the Who's Who Legal Commercial Arbitration and is recognized as a local elite thought leader at a Tier 1 arbitrator in chambers. With extensive experience as arbitrator, counsel, and expert, he has participated in ad hoc and institutional proceedings under leading arbitral rules, including ICC, ICSID, LCIA, and the ad hoc proceedings under UNCITRAL, involving parties from over 60 jurisdictions and diverse industries. He is also the driving force behind the Queen Mary empirical surveys on international arbitration, a cornerstone of arbitration research since 2005. We are honored to invite Professor Mistelis to deliver a presentation on the increasing role of mandatory rules in the international arbitration, exploring the growing influence of these rules on the practice and theory of arbitration worldwide. Please, the floor is yours.
Thank you very much. I would like to extend my thanks to the organizers of this 5th World Congress. I think I've managed to attend 4 out of the 5, so I've done very well, and I will try to cover what I wanted to cover, bearing in mind that we are about 40 minutes past the projected end of the day,
and trying not to match the speed of Dr. Mohammed. So, mandatory rules and issues that have to do with broader, let me see whether that would work. We heard quite a bit about applicable law in the last hour and 10 minutes. And arbitration in a purely domestic context could be quite simple. Perhaps a large number of the arbitrations are like that. But when the arbitration has cross-border elements, it becomes a much more complicated matter. I have been describing that as a regulatory cake. So you've seen that we have matters. We had about lex arbitri, the law governing the arbitration procedure. We looked about the law governing the merits. We also looked about jurisdiction. That is how the parties themselves or the law allow them to refer certain types of disputes to arbitration, and whether the law takes certain disputes outside the scope of the arbitral process. We talked about the capacity of parties to enter the arbitration, and we looked at about enforcement, because when we speak about principle of validation, we look very much about the outcome and the duty of the arbitrators to render an enforceable award. A part of these various topical issues, various issues where applicable law might become a matter, we have another problem of complexity, which was addressed by a number of the panelists already. The various sources of regulation of the arbitration process and the dispute before the tribunal is we have as a particular complex issue that not all the rules are of the same density, I would call them. So we have hard law applying, we have soft law applying, we have international treaties, international custom, we also have a lot of sort of general practice and standards. And of course that's, we always swing between procedure and substance. An additional, of course, complication in arbitration is that perhaps in arbitration this dichotomy between substance and procedure, which is very common in all legal systems, is no longer appropriate in arbitration. In arbitration we have not a dichotomy, but we have a trichotomy. We have jurisdiction, we have procedure, and we have substance. So all of these matters are often sort of, we talked about the relevance of law and the relevance of the national courts. Statistics suggest that only about 10% of the arbitration cases interact with national courts. That's perhaps my contribution, if you wish, to the question of lex arbitri. I mean, when it comes to how the arbitration is being run, what happens behind closed doors in the arbitration process, what I will call an internal lex arbitri, the tribunals have almost unlimited discretion what to do. The things change once the door opens and we get into the interaction of this arbitration with the national court. And that's why a lot of commentators, for example, Redfern and Hunter, only deal with that side and they ignore the other matter. Now, arbitrators, where they have the power, they use what they know best, their own experience, the procedural culture that's relevant to arbitration. Now, that's all sort of the way has been evolving until perhaps about 30 or 40 years. Because then we started looking at the concept of mandatory rules or mandatory law. And in the next 5 minutes, 6 minutes, I will dedicate sort of my comments on that very issue. So we talked about density. We have soft law. We also know the concept of jus cogens, a law from which the parties cannot derogate by agreement. If you look at the majority of the procedural rules of arbitration, whether in a domestic arbitration legislation or a set of arbitral rules like QICCA or ICC, we often see this typical sort of phrase, unless otherwise agreed by the parties, the default rule is that. Or the parties are free to agree, save that that's what will apply as the default solution. But the mandatory rules is where the discretion of the parties is limited. And that's the same in terms of applicable to the substance of the case. We know that some jurisdictions are very restrictive. For example, if you have a dispute between two Russian parties or a dispute between two Chinese parties, you cannot choose that dispute to be governed by English law because you internationalize the dispute and that is not allowed by the system. Now, permissive systems, most of the European systems, North American, etc., parties can choose to the dispute a law not connected to them because it's a neutral law. They like it. They think that will give them better justice. And that choice is normally being upheld to the extent that doesn't sort of conflict with sort of mandatory rules. Now, the concept of mandatory rules is effectively the, we describe that sort of the other side of the coin of public policy. Public policy is a topic which is heavily debated, and we describe public policy as a shield. Parties make a choice, but you cannot penetrate that shield because there are core values in every legal system when it comes to enforcement, when it comes to applicable law, that the system would not allow you to come through. So public policy is defensive. Mandatory law, however, is aggressive, is offensive. So this is rules that will apply, notwithstanding what the parties have chosen, because that rules are what we describe overriding statutes. Interestingly enough, the French terminology about mandatory rules is loi de police. Like police can stop you at any time and tell you what to do. Even if you have a traffic light which says red, the police can tell you to go drive over red or to drive or to stop at the green. So if you then have, the German term, of course, is Eingriffsnormen, which is attacking norms. The parties are free to make choices, but this choice can be attacked and be set aside by mandatory rules. The English have used primarily the term overriding statutes, and we have different versions of that in the US and in other languages. Now, the mandatory rules, the way they interact in arbitration, they interact in two different ways. They interact in terms of jurisdiction, procedure, what the tribunal can or cannot do. For example, we have seen over the years that if the subject matter of the arbitration relates to competition or antitrust law matters, maybe the arbitrations should not proceed and the matter should be referred to the competent authorities. Of course, modern jurisprudence of the last 40 years suggests that the tribunal could go ahead with the case because if the tribunal did not exercise the jurisdiction correctly, the courts have what we describe as a second thought. That comes from cases like Mitsubishi and Solar. Similarly, when a party becomes insolvent before or during the arbitration, the argument has been in the past that that party is losing its legal capacity. Of course, there are different stages of insolvency. You can just be in hospital, or you can be in hospital and connected to a life support machine. The life support machine is the trustee in the bankruptcy, which can switch on or off your life support machine, and therefore you exist or you not exist. But if you are in a preventive system, in a sort of Chapter 11 US type bankruptcy, the arbitration can easily continue, and that was the matter where the sort of aspects are separated between what is possible and what's not possible. But we've seen a number of aspects of law which have penetrated the substance of the disputes in the last 20 years, and the last one is perhaps more prominent in the last few years. So we've seen that certain laws about environmental protection can affect a way of a concession has been granted, or a mining contract is operating, or an oil exploration is operated, because some of this environmental protection are overriding statutes. We have that in consumer and labor laws, which sometimes interact with arbitration. But the most recent scenario is sanctions. Sanctions is not very new, but in arbitral context, the most important sanctions started about around the sort of Arab Spring. So out of the Libyan revolution, if you wish, in February 2011, we have had a number of cases where institutions were caught off guard. I was one of these cases in the ICC. The matters were progressing, awards were made in jurisdiction, and then banks that operate in a compliance environment say, come on, you cannot be paid because one party is linked to a sanctioned party, and any movement of money, any award the tribunal could make could mean that we violate sanctions that exist about Libya. Of course, we've seen a lot of sanctions relating to Iran, and we've seen a variation of what was happening that only in a case before the English courts very recently. There's this sort of long dispute between NIOC and the State of Israel, where the National Iranian Oil Company prevailed. the National Iranian Oil Company tried to enforce the award against Israel, and the English courts told them you cannot enforce, because if you enforce that award, it means that money will move to a sanctioned entity, the National Iranian Oil Company, and that would not be in accordance with mandatory rules. In a very recent English case, which has been reported only this week, the English courts have taken a very different view to the case in the NIOC. An award can be enforced, notwithstanding sanctions, but the money cannot move to the account of the winning party, which is a sanctioned party, but has to be in a ring-fenced account in the control of the court, or in some cases the control of a tribunal. And of course now we have many sanction cases relating to Russia, where we have seen anti-suit injunctions blocking the jurisdiction of tribunals. We've seen cases going to the substance, whether payments can be made in currencies different than the ordered sort of currency or the contract provided within the contract. So sanctions have been there, quite present. We've also seen actions to defy sanctions. I mean, we've seen people being delisted from European sanctions. There's many more actions taking place in that space in the arbitration context. And of course, we understand that access to justice suggests that even in the context of sanctions, law firms can apply to get a license to operate in this environment, but it's very complicated. Now, what is happening, because this region is a bit less impacted by sanctions, especially UK, US, EU sanctions, we see a lot of arbitrators from the region being active in this type of cases of sanctions, cases that could not be taken by English, American, or European arbitrators. So, of course, when it comes then to mandatory rules, the question is which mandatory rules or which public policy is relevant? The question we've had is that the law of the seat, should the tribunal observe the mandatory rules and the public policy of the law of the seat? Or is that the law of the main contract? Or it could be some other place. Can we also look at the place of enforcement? Why should I bother about sanctions rendered by Russia if the award could be enforced elsewhere, in Vienna, or in Sweden, or Germany, where I can find assets? And of course, what is the authority that a tribunal has to apply any mandatory rules altogether? A lot of public policy is directed to national courts specifically, because national courts are guardians of public policy. Mandatory law, of course, is written, is part of the sort of statutory law you would apply, but on what basis do you apply? And do you sort of take a preemptive action if the seat of the arbitration is permissive, because it doesn't care about sanctions, but the place of enforcement would not permit it? And how that will reconcile with the idea that a tribunal has a duty to render an enforceable award. So we've seen a conundrum, a paradox, which is proliferated rather than being controlled, because the legal system and the interference of regulation with arbitration does not always give us solutions, most likely gives us problems. And that's where I would like to thank you.
Thank you, Professor. I would now give the audience, if they have any questions. Microphone, please.
First of all, I would like to thank the esteemed panelists. And I have one question for Professor Bernard, and another small comment on the localization and delocalization of the arbitral law. The question is that in the third arbitration case that Your Honor have mentioned, but didn't complete, in fact, you said that Article 9 of the Investment Convention said investors shall be bound by the laws and regulations of the host state. But you didn't complete how did you choose the applicable law. My question is that I wonder whether the tribunal construed this article as mentioning to the overriding mandatory rules instead of the substantive applicable law? Okay. Should I repeat the question?
Could you please repeat the question?
Yes. In the third arbitration case that you have mentioned but didn't complete, you said that Article 9 of the Convention states that the investor shall be bound by the laws and regulations of the host state. I wonder whether the tribunal construed the article as mentioning to the overriding mandatory rules instead of the substantive applicable law?
Well, the answer to that is, in this concrete tribunal, we had, the host state was Indonesia, but the seat of arbitration was Singapore. In that, we had the question, what applicable law should be taken into consideration? And in this concrete case, the applicable law was not very important because we didn't go to the merits in the sense that we thought there was no jurisdiction, and due to external questions, and we didn't go into the merits. That was the reason why it was not so important what was the applicable law.
Thank you. I have another point regarding the localization and delocalization of the arbitral.
If I make a comment on that question.
Okay.
Normally what we see in investment cases, Article 9 of the OIC, if you look at Article 42 of the QICCA Convention, the typical scenario is that you apply the law of the state that is hosting the investment, but that law is controlled by international law. So the application of domestic law in these investment cases has to be in consistency with international obligations of the state, and that perhaps some of it is mandatory.
Thank you.
Let's see if there's somebody else before. Yeah, please, here. Another one? No, but to give chances for others before. Okay. Here, please.
شكرا جزيلا لجميع الأساتذة الأفاضل على مداخلاتهم القيمة بخصوص مسائل في غاية الأهمية، وهي القانون الواجب التطبيق على الإجراءات والقانون الواجب التطبيق على اتفاق التحكيم. حقيقة هو مداخلة بسيطة بأكثر منها سؤال، إنه في مسألة في غاية الأهمية كنت أود يعني المداخلة فيها من قبل الزملاء، تتعلق ب لماذا يثار موضوع القانون الواجب التطبيق على اتفاق التحكيم استقلالا عن القانون الواجب التطبيق على العقد نفسه. السبب في ذلك كما نعلم هو مبدأ استقلال شرط التحكيم عن العقد الأصلي أو separability doctrine of the arbitration agreement. في الحقيقة دائما الحديث في القانون الواجب التطبيق على اتفاق التحكيم يرتبط ارتباطا وثيقا بالقانون الواجب التطبيق على الإجراءات، وهو البروسيجرال رول. لأنه أنا عندما أتفق على التحكيم في دولة قطر، حتى ولو لم أحدد القانون الواجب التطبيق على هذا الاتفاق، فضمنا أن القانون الواجب التطبيق على اتفاق التحكيم هو القانون القطري، وأن القانون الإجرائي أيضا هو قانون التحكيم القطري. أما مسألة تحديد اللي هو القانون الموضوعي الواجب التطبيق على موضوع النزاع، فقد حسمته بعض القوانين جعلته بالرجوع إلى قواعد تنازع القوانين كما فعل المشرع القطري للكونفليكت اوف لو رولز. بعض القوانين لا، أعطت لهيئة التحكيم سلطة تحديد القانون الأكثر اتصالا بموضوع النزاع طالما الأطراف لم يتفقوا صراحة على القانون الواجب التطبيق على موضوع النزاع. أنا سؤالي فقط الآن، أين تتجه إنجلترا لبروفيسور كيم؟ أين تتجه إنجلترا فيما يتعلق بالقانون الواجب التطبيق على اتفاق التحكيم؟ القضايا الإنجليزية المختلفة منها قضية كبابجي والقضايا الأخرى، جعلت القانون واجب التطبيق على اتفاق التحكيم هو قانون العقد نفسه، على خلاف المنهج الفرنسي مباشرة. الآن اللو كوميشن لهم بيشتغلوا حوالي سنتين على التعديل، قالوا إنه إحنا بدنا نروح على النهج الآخر اللي هو القانون السيك اوف اربتريشن أو قانون مقر التحكيم. سؤالي لماذا هذا التغير في نهج المشرع الإنجليزي، وهل سنشهد قريبا صدور هذا القانون أو التعديل على القانون اللي إلنا بننتظره يعني فترة تزيد عن السنة ونص تقريبا؟ شكرا.
I think the short answer is the Commission has gone through extensive consultations on this issue, soliciting views from the entire industry, law firms in the UK particularly, and around the world. And I'm sure, and the prevailing view of the industry is that it should be the law of the seat. So that's just the recommendation of the Law Commission. And of course, that has to be formally adopted by the UK legislature. The prediction is, and probably Lucas has better insight than I do, that it's going to happen next year. And then it becomes law. Then it has to be followed. That's what I'm told, but I don't know if you know if it's going to happen sooner than that.
It won't happen sooner, it will happen in 2025, I assume.
Yeah.
I think England has been historically a localization jurisdiction, and that's reflected in sections 2 and 4 of the English Arbitration Act. Because once you land in England, English law would apply. English courts would have jurisdiction. Interestingly enough, section 4 is very unusual because section 4 classifies the 100 plus sections as being mandatory or non-mandatory. And Schedule 1 has a list of mandatory provisions in the English Act. But the English think that is a better level of certainty to apply the seat and not the law of the contract. It's also a matter of separability because, as we've discussed, the arbitration agreement is deemed to be a procedural agreement and not the matter of the substance, so this has to be separated. And the traditional, apologies for using Latin, sort of forum regit processum, sort of the seat regulates procedure and everything else is regulated by contract. So that's what England sort of espouses in that sense.
We have
السلام عليكم. الدكتور نادر ما شاء الله كلام جميل، وفي حضرتك يعني جبته في إطار الفلسفي والجدلي.
الميكروفون please.
لكن أحيانا الواحد قد ينتهي إلى حديث غير قطعي. حضرتك أثرت مسألة قانون واجب التطبيق. أنا أقول لأن تم الحديث فيه من خلال عدة معايير، يعني أحد المعايير التي تحسم قانون واجب التطبيق في إطار التحكيم المحلي والتحكيم الدولي. نفترض الآن قطر، أرض قطر، إذا ثبت أن كل المعايير في قطر، يعني الأطراف قطريين وعلى أرض قطر ومركز قطر، فإن التحكيم محلي، وممكن يكون تحكيم دولي وعلى أرض قطر كمان، على أرض قطر. إذا اتصل بالمعايير، لأن هناك عدة معايير في دول اتخذت زي الإمارات اتخذت 4 معايير لأن يكون تحكيما دوليا، وأغلب الدول اتخذت معيار واحد، اتصال الواقع بالتجارة الدولية، إذن لو الاثنين على أرض قطر لما يكون دولي، هنا حيكون في الخيار لتعدد المنظومة القانونية، لا اختيار قانون واجب التطبيق وليس شرطا قانون القطري، ولكن لما يكون محلي هو ملزم بتطبيق القانون قانون القاضي القطري. فأعتقد قد يكون في هذه المسألة سنبتعد عن الفلسفة الجدلية في هذا الموضوع. بالنسبة للمسألة الثانية، حضرتك أثرت موضوع أخونا الكبير أستاذ زمان أيضا مسألة الإحالة. برضو احنا عشان نتخلص من هاي المسألة أن المشرع أو رأي اشترط الإحالة العامة أو الإحالة الخاصة، احنا لازم شوي ننزل زي ما كتبت الأستاذة عميدة كلية القانون من اسكندرية الأستاذة حفيظة حداد، تقول يا جماعة الخير عشان راية التحكيم يرتفع يجب أن القضاء والتشريع يعامل التحكيم تعاملا لينا وليس خشنا عشان التحكيم ياخذ طريقه. دلوقتي احنا نقول متى ما تم العقد اتفاق التحكيم انبثق عنه ماذا؟ أثرين. الأثر الأول وهو سلبي نزع الاختصاص من القضاء، أما الأثر الثاني وهو الإيجابي جملة من الخيارات أكثر من القضاء. القاضي مقيد ولكن المحكم إيش؟ مطلق له العنان. طب إذا كان في القضاء
في سؤال يعني بس أنه
بس
يعني
هذا إذا كان احنا نقول أن في التحكيم في خيارات، طب لماذا أنه هو مسألة الإحالة لماذا نعقدها؟ لماذا لا نعقد مسألة الإحالة؟ يعني مثلا في البحر في عقد النقل وفي سند الشحن يجي يحتاج يقول لك لا ورد في السند الشحن ما وردش في العقد، فهذا تعقيد أعتقد. شكرا.
دكتور نادر تحب تجاوب أو
نظرية الإحالة الخاصة لها احترامها ولها وجودها، وقد تبنتها اتفاقية هامبورغ في المادة 22 نقلاً عن الاجتهاد القضائي الإنجليزي، وحددت متى تكون هناك إحالة خاصة. وهذا الموضوع يكتب فيه باللغة الإنجليزية تحت عنوان incorporation of the arbitration clause. يعني أنا عندما أخذه من القانون الآخر to incorporate. متى يحدث الانكوربريشن؟ قالت مثلا لو اللفظ الموجود في سند الشحن لفظ التحكيم، بمعنى إذا كتب في سند الشحن all the terms and the conditions of the charter party dated so are incorporated حسب القانون الإنجليزي this is not specific. لكن لو كتب فيها كلمة arbitration including the arbitration clause ده اسمها specific. لو أعطيتك نسخة مع سند الشحن لشارتر بارتي وفيها الاربيتريشن كلوز this is specific. لو أحلت إلى شارتر بارتي مثلا الجنكن شارتر بارتي سنة 94 فيها arbitration كلوز، وأنت لو عملت سيرش على النت هتطلعها. إذا لما كتب لك في سند شحن مستخرج من الجنكن شارتر بارتي قال لك أنا I make reference to the standard وستاندرد فيها الاربيتريشن كلوز يبقى ده specific. هذه هي النظرية اللي فيها استقرار للمعاملات. تعرف الإنجليزي يحبوا الاستقرار للمعاملات. أنا متفاهم الرأي الموجود في إنجلترا بتاع specific arbitration specific reference. هذا موجود بنص صريح في اتفاقية هامبورغ. وإذا أقول لك أن بعد نفاذ اتفاقية هامبورغ في مصر وهذا من سنة 92 لا تستطيع القضاء المصري أنه يستخدم الإحالة العامة. لكن فيما يتعلق بالنطاق الآخر العام والذي يتحدث، احنا لدينا نفس النص الموجود في القانون القطري. ما هو المقصود بالواضح؟ هل هو العام أم هو الخاص؟ تأتي القضايا ونرى. القضاء القطري قال كلمته أنه لن يتشدد وأنه سوف يكتفي بالإحالة العامة. هل سوف يفعل ذلك القضاء المصري؟ لا نعلم. وكما ذكرت لك كل الدول التي طبقت هذا النص طبقته بمفاهيم مختلفة. في النهاية هي يا إما أنت مناصر للتحكيم فتيسر، ويا إما أنت متشدد مع التحكيم فتطلب ينبغي تكون specific.
We will take the last question or two questions here and but quickly please because we need to
بسم الله الرحمن الرحيم. في البداية أحب أشكر دولة قطر ومركز تحكيم قطر على هذه الاستضافة والمؤتمر الرائع. سؤالي يقول ما هو الوضع القانون الواجب التطبيق على التحكيم الإلكتروني في حالة اختلاف جنسية الأطراف وفي حالة اختلاف مكان التحكيم؟ مثلا أنا كأطراف مسافرين في رحلة عمل في مثل هذا المؤتمر، واتفقنا على عقد، تمت صفقة بيننا، اتفقنا على عقد، وهذا العقد كان محل قطر، والأطراف جناسيهم مختلفة من دول مختلفة، لنفترض من كوريا ومن إنجلترا. ما هو القانون الواجب التطبيق في هذه الحالة إن كان التحكيم إلكتروني؟
ما هو القانون واجب التطبيق على الأهلية ولا الشكل ولا الموضوع ولا الإجراء؟ وإحنا كلنا كل واحد فينا كان واخد موضوع عشان نعرف مين اللي بيتوجه إليه السؤال.
أوكي، من الناحية الإجرائية
دكتور محمد معنا مصر.
دكتور محمد عمر، محمد سامح عمر اعتقد انه انسحب لانه كان
طبعا
مرتبط بجلسه تحكيم. انت ممكن
هذا السؤال يتصل بما هو المقصود بالمكان. مكان التحكيم ليس هو المقصود به المكان الفعلي، المكان الفيزيكال. فإذا كانوا قد اتفقوا أن مكان التحكيم في الدوحة ولكنهم يتواصلون من خارج الدوحة واتصال إلكتروني، نحن نعتبر أن المكان هو الدوحة، وهذه حلت. المشكلة أنه ماذا لو لم يختاروا، أنا بقى أرسل إليك المشكلة، ماذا لو لم يختاروا المكان؟ أنا ذكرت لك أن قاعدة ليكس لوسي أربيتري اللي هو تطبيق قانون المكان بيفترض أن هو اتفقوا على المكان أو هناك إمكانية لتحديد حتى بشكل غير مباشر ما هو المكان الذي اختاروه. لكن إذا لم يختاروا مكانا لدينا مشكلة. ما هي حلها؟ ليست كل الأسئلة القانونية لها إجابات.
أنا برأيي ما يكون
بس في بعض الناس مش هترضى بطريقة إجابتي يعني.
القانون الأكثر ملائمة للأطراف؟
الأقرب إلى الأقرب إلى الإجراءات، الأقرب للإجراءات الذي يصححها.
This is the last question, and we will be concluding.
Thank you. My name is Nicola Yuta, and I just wanted to make a comment, actually, as an English solicitor, in order to make more clear why the seat of the arbitration was referred to as a preferred criterion in order to define the law applicable to the arbitration agreement. To the extent that a state is the only sovereign within its own territory, that's the principle, any activity within that territory should be governed by the law of that state. And by choosing the seat, the parties have indicated as a result of this artifice the fact that that activity, that procedure, will have to take place within a certain territory. And that's why there is a predominant idea that the law of that state should govern the activity, that is the procedure. And that is why we're speaking about the localization of the arbitral procedure. And that is why there has been also this trend, scholarly trend, that was mainly developed by Professor Emmanuel Gaillard and by French scholars, whereby we should have considered the arbitral procedures delocalized and independent from all states. And that's why the French doctrine conceived the idea that the arbitral procedures should not be governed by the law of a specific state. From the point of view of English law, instead, the Enka versus Chubb case that early on today was indicated by Gary Bourne has been confirmed, has confirmed the trend that English courts had preferred, and has confirmed that whenever you have an arbitration agreement within a contract, the law chosen by the party to be applicable to the underlying contract should be intuitively applicable also to the arbitration agreement, to the extent that the parties had not chosen the arbitration agreement law, unless, obviously, the parties have chosen a specific law applicable to the arbitration agreement. But in that particular case, a law was not chosen, and that's why there was a need of defining exactly what was the law applicable. And the approach chosen by the English court was, in fact, to apply the law of the underlying contract. But the Law Commission has, after the consultation with various law firms, and also including King's College, by the way, have, out of concerns of uniformity and in order to comply with the general principle of sovereignty of the state, suggested that the law of the seat should be actually governing the arbitration agreement. I hope this is what, I mean, it's more clear to position all the various thoughts and principles in the place.
Thank you. Thank you all for being here today and giving these outstanding presentations. These are very insightful. Please, now there will be an honoring from QICCA for the panelists.
والآن ندعو الدكتور محمد عبد الله الكواري فليتفضل مشكورا لتكريم أعضاء الجلسة الثالثة. البروفيسور الدكتور برناردو كريميديس. الأستاذ طارق اللبان. البروفيسور الدكتور لوكاس مايستلز. البروفيسور الدكتور جونغي كيم. الدكتور نادر إبراهيم. كما نشكر الدكتور محمد سامح عمرو على مشاركته في فعاليات المؤتمر. السيدات والسادة المتحدثين والحضور الكرام، نشكركم جميعاً على حضوركم ومشاركتكم في فعاليات اليوم الأول من المؤتمر، على أن نلقاكم في تمام الساعة 7:30 في العشاء الرسمي لفعاليات المؤتمر. والسلام عليكم ورحمة الله وبركاته.